not race related, is when a landlord refuses to make a reasonable accommodation to move their rental payment dates, because you always get paid on the first. Rent date's always on the first. That could be a form of disparate impact discrimination. Now, if I make a reasonable accommodation request, that's going to be a disparate treatment, and that's a direct discriminatory action. But that's like a neutral policy that at its face seems pretty okay, but can lead to a discriminatory claim down the road. Color discrimination, very similar to race, but it's based on the complexion of the person. I do see this not as common, but I do sometimes have tenants, for instance, who are darker skinned individuals who have a harder time when it comes to applying places. And we were able to identify in the last 5 years one landlord who was explicitly like quick to file an eviction against a dark skinned tenant for issues they were not doing for lighter skinned tenants. National origin discrimination, a lot of these first three kind of all overlap. Like, candidly, usually if I have a race-based discrimination claim, I can also, if I want to, bring a color-based, and nation-based can go a little bit further from there. This, like I said, it's what nation you perceive this coming from. What I run into this is the most often recently has been, it's not a common claim, but a couple of years ago, especially when the Ukraine-Russia conflict first started, we were running into issues where Ukrainian landlords weren't going to rent to a Russian tenant or vice versa because of the conflict happening back home. Not allowed. You can't do that. There's similar case law. It's a completely different legal structure, but like in Europe, there's a lot of conversations around like gypsy people, Romani people, and they face discriminatory through that. It's a similar thought process. If someone's believed to be of a nationality and you treat them differently because of that, you're violating the Fair Housing Act. What I run into the most frequent with this is cooking. So I will have landlords who will go, well, I don't want to rent to a Somali person because their cooking smells. That's a form of discrimination in the Fair Housing Act. You will be liable for that. Religious discrimination, you can't discriminate against someone because of their religious beliefs. This also means that you can't discriminate against someone because of your religious beliefs. I had a client who found a nice older woman who was renting to her. They got along great because they were both Christians. My client was a lesbian woman. The landlord didn't know. My client got a wife. Landlord comes up and goes, I thought you said you were Christian. And she goes, I am. The next day she had a 3-day notice that they were evicting her. You can't do that. Now you also, like, if you were a tenant and you went to rent somewhere and you were practicing some religious ceremony or something that the landlord didn't like, you can't be evicted for that. An exception does exist if that ceremony poses a direct threat to the health and safety of the community. There's some case law out of Dayton where a religious sect from a tribal community in I believe South America had a religious ceremony where they did animal sacrifice. That was not covered by the Fair Housing Act because the sacrifice led to like blood and other fecal matter that would come across the common area. That was a risk to the health and safety of the community, therefore are not covered by this clause of the Fair Housing Act. Unfortunately, other than disability discrimination, this is actually what my office does the most litigation around, is sex-based discrimination. There's two different types of sex-based discrimination that come up. You can get quid pro quo or a hostile environment when it comes to a sexual harassment claim. Quid pro quo, that's what everyone thinks about when they hear sexual harassment. That's, see, you do this and I'll fix your washing machine. Or if you don't want to pay rent, you can do something other than pay with cash. Hostile environment, this is actually where I see landlords get the most frequently tripped up. That's when, be it your staff, yourself, or someone else who is employed by you, is routinely asking a tenant out on dates or saying, hey, why won't you go on a date with me? Why won't you do this? And the client keeps saying, no, please, no, don't want to do that, not interested. If a landlord is put on notice about that and doesn't take any action, they can be held liable for the acts of their employees. It's a stereotype, but I do frequently run into issues with maintenance men and doing things like this. This is for anyone who, if you live in a subsidized housing property, be it with a voucher, be it with project-based voucher, home choice voucher, anything like that, the Violence Against Women Act applies. Are any of you all familiar with the VAWA? Okay. Despite the name, it does apply to anybody. I have had to argue with numerous senior attorneys who would look to the judge and go, "But Your Honor, defendant is a man." And I'd be like, "Your Honor, that doesn't matter." And there's one attorney in particular I've gone up against 4 times in that matter. He just won't budge. Um, Protects victims of domestic violence, dating violence, stalking, or sexual assault for anyone living in a federally subsidized housing. What I always tell tenants, and this is a good way for you all to figure out if your housing is federally subsidized, because believe it or not, some landlords do not know this. If they're updating you with their income every year or telling you what their status, the family composition is, it's going to fall into VAWA. Like I said, it's any victim of stalking, threatened domestic violence, dating violence, sexual assault. It's also anyone affiliated with the victim. So I have had a case where the adult daughter of a client, of a tenant, invoked VAWA to get the family moved because mom wasn't comfortable bringing it up. To prove that someone's a victim of domestic violence, basically anything can take place. This is talking about how you can help someone. Like it basically makes it to where a tenant can be moved to a different property. So like if you own numerous properties across the state, well, city, not state, I'm not going to ask you to move someone to Cleveland. But if you own some place in Clintonville, for instance, and you own some place in Grove City or something like that, the tenant under VAWA could ask to be transferred to a different property because the stalker knows where they live. Additionally, you can't hold that victim responsible financially for the damage done to the property by the abuser. Plus side for you all, if it's a situation where the couple's married or they're dating and they've been living on the lease together, under VAWA, you can break the lease, you can cut it in half and be like, okay, abuser, you have to get out. And you can hold the abuser responsible for the cost of damage and all that. But you can't hold the actual victim responsible. No, VAWA is applied. It was actually renewed by the first Trump administration. And under that renewal, it had no sunset clause. So it's just the law going forward. But it only covers those properties which are federally assisted by federal cash. So if you're a project-based subsidy, or if you have specific money coming directly to you, not through a voucher, but to you, then that means VAWA is going to apply. Now, what I will say is for all of you who don't live in federally subsidized or rent federally subsidized housing out, these can all give claims under sex-based discrimination lawsuits. It's a bit murkier, but that is still a claim that can be brought. So generally what I tell landlords is best practice, if you can, like afford to, just generally operate as if you're covered by VAWA, because that's going to protect you against any single sex-based discrimination claim that someone's going to bring you under as a victim of DV. You're not necessarily liable for everything that you would be under VAWA, but it just makes it cleanest for you all. Did you raise your hand? Got it. Okay. Got it. Tenants need to ask, though, for protection of VAWA, generally also with non-VAWA properties. Police reports, court records, documentation by professional. So like I could write a letter saying that my client was a victim of domestic violence. Landlords need to accept that as proof. And even if need be, a tenant can sign an affidavit stating that they themselves are a victim of domestic violence. The whole idea behind it is we don't want to create a high standard for like a victim who's in an already vulnerable place to have to meet. Now, if they make something up, you guys can just go no, or if they're not giving you anything, it can be refused. But generally, if they give you any kind of documentation that has any semblance of legitimacy, probably should just work with them. Like I said, if you're not renting out federally assisted housing, you're probably still going to have a claim come up under those VAWA-like situations based on sex-based claims. So just generally best practice is to work with anybody who says they're a victim of domestic violence unless there's clear proof or knowledge in your part that that's not what happened. And believe me, occasionally I do have clients where they go, it was DV. And I go, no, it wasn't DV. The person, like I had one client where her husband was on being deployed and had been deployed and the property got destroyed by her kids. And she said there was a DV incident. And familial status discrimination, you can't discriminate against a family based on their composition. This is most often thought about with like single mothers with kids is when I run into this most often, where a landlord doesn't want to rent to a single mom with multiple kids because, quote, well, she can't handle those kids. That's a form of familial discrimination. Where this gets a bit more messy is situations that are covered by law, but I think more morally gray. If you have tenants that you're renting to who are participating in the abuse, neglect, dependencies programs in the city, and they may be taking on temporary custody of like a grandchild and nephew, things like that. An issue we run into a lot in Appalachian, Ohio, with the opioid epidemic happening. Technically, you should just work with that tenant to add that child to the lease for that time, or else there could be a familial status discrimination claim filed against you. This is just if you're, I don't think anyone here probably falls into this, but if you're renting out senior housing, you're generally excluded from familial status discrimination claims under federal law. That's because the senior housing properties often have 55 and plus requirements. And so this exception is built in so that families weren't bringing in all their grandchildren or children and disturbing those communities. I will say it's not 100% an exception though. You should, if you, I don't think it's here, but if a landlord thinks they're running senior subsidized property, look heavily into the agreements you've signed because some of them only require that like 55% of the apartments be rented out to seniors. And that could open up dangerous price tags effectively for any of y'all. This is what most reasonable accommodation, most of my fair housing work takes place under. It's discrimination based on disability or working around people with disabilities and helping them get accommodations. Any individual with a physical and mental impairment that substantially limits one or more major life activity, has a record of such impairment, or is regarded. The record of such impairment, what that one come up the most often as is if someone's getting treatment for addiction services, you can't discriminate against them or evict them or refuse to rent to them because they're getting treatment for addiction services. Now, if they're actively using, that's a different conversation. And active use is not considered a disability. But we have run into cases where, for instance, a landlord didn't want to rent to someone who was going through a methadone clinic and getting treatment and working on that. That's not allowed. Regarded as is very similar to the nationality situation. I've had a client who got called a few slurs based on the perceived intellectual ability of them. Client had no actual disability, but that was a real nice $20,000 paycheck for my client because the landlord put it in writing in text messages, not just one, dozens of text messages where he just kept yelling at her. And he followed it at her kid's school once. It was very weird, but that was a nice $20,000 paycheck for my client that she got relatively quickly because he put it in writing. Conversely, I know I've been using writing as examples of landlords messing up. Just put everything in writing. I tell my clients to put everything in writing, but it also helps out the landlords because I have clients. I had a client who was making up that she had been threatened for familiar status and that the landlord was going to assault her and all these other things. And I looked into it, looked through all the text. And what had happened was she was outing him as a gay man through all his community and church in southeast Ohio. And so like he was afraid, he was worried what was going to happen. He'd received a death threat from someone in the community he grew up in. And at one point he had a video of her calling him a bunch of slurs. He flinched towards her out of anger, but then stopped. And that was the claim she was making. But everything was in writing. So when I looked through the text messages that the landlord gave me, I said, you're going to do a 3-week move out or you're finding a different attorney because we're not representing you in this case. So just everything in writing, just it helps everybody. As far as disabilities go, major life activities, it can be, like I said, anything. Literally one of the big cases is PGA v. Martin that was interpreting the Americans with Disabilities Act. That was the Professional Golf Association versus Martin, and it was a lawsuit over whether or not he could use a golf cart during the Masters. I'm not much of a golf person, but I do understand because of that case law that the walking of the whole golf course is a big point of it. That can be a major life activity. Thank you for asking that question because I usually bring it up and I forgot to. That is the one exception. I do run into that actually a lot with some of our immigrant community in Columbus where they moved in 5-6 years ago. New property manager takes over, does like a whole evaluation of who's all living everywhere. And since then, the family's had 4 or 5 kids. And so they can't fit there anymore. That is an exception to the familial status discrimination because I can't, for any of these things, ask you to do something illegal under the Fair Housing Act. So I can't say. It's 2 people per bedroom plus 1 for a couch. But there's also a weird, double check, because I know there's been some talk about changing the statute, but I don't think it's got changed recently. There's a weird thing about teenage siblings of different genders, where there is, I believe, written into certain townships in the area, codes that state that opposite gendered teenage siblings cannot share a room. Is anyone actually enforcing that? No, I think just the pure number of people is going to be the bigger problem, but just be aware. You want to keep aware to make sure you're not actively putting yourself in legal danger. Other examples of major life activities, though, AIDS, chronic mental illness, alcoholism. Like I said, with the drug use, that needs to be treatment. It's not that someone's currently an alcoholic and they're causing a problem and you can't do anything. Sex offenders are not considered disabled. There's some really fascinating academic and like legal theory discussions about how a lot of sex offenders are like candidly, a lot of them have mental health disabilities or other disabilities in the past that have caused them to get to that point, but it's not considered a disability. It's a good example actually of why any disability isn't a pure excuse for someone to do what they want to do. You can't pose a direct threat to the community or members of your apartment complex. So any reasonable accommodation, I would ask of you all, if it poses a direct threat, that's a reason that a reasonable accommodation request can't be denied. These are different types of disability discrimination. There's different treatment. That's the very clear one that is, I don't want to rent to you because you use a wheelchair and I don't want to deal with all the scuffs on the walls. Unjustified discriminatory effect. That's what I talked about, the disparate impact of moving. I've fought with this a lot. If I make a reasonable accommodation request to you all to move the rental date past the 1st and the tenant's only source of income is SSDI, that is a valid reasonable accommodation request. Now, if they have other income, that's a different conversation and we have to really evaluate. I had one client who got $1,200 in child support payments along with her SSDI. We didn't make the reasonable accommodation request because she had other income. But that's an example of a generally neutral policy that can actually significantly impact people with disabilities, because I actually have a case right now where a client was about to be set out. He had racked together $1,200 in late fees because he had asked 24 months ago, can you move my rental date to the Tuesday after I get my Social Security disability because that's my only income? And the landlord said no. I understand it's a slightly bitter pill to swallow for some landlords because they get used to the first is when you pay rent, but just keep that in mind. A denial of a reasonable accommodation and a denial of a reasonable modification are also forms of discrimination. Accommodation is different than this. I thought my reasonable accommodation was my next slide. I haven't used this presentation in a bit. But reasonable modifications are when you change the structure. So that's rolling it, like creating a roll-in shower for a tenant who uses a wheelchair, building a ramp, things like that. You can only refuse a reasonable modification if it would cost you an unnecessary burden, like financial burden. And that is a per case discussion. I had one landlord who advertised their $25 million portfolio, and they tried to tell me the $8,000 for their shower that I was requesting for my client would be too expensive, and they could not do it because it would cause an undue financial burden. I sent a very happy email where I did to the decimal point what percentage of their yearly portfolio that would cost, and asked them to prove to me that was an undue financial burden. Now, if you're a smaller landlord, that's an easier standard to reach, though. Like if you point, you go, I own 4 homes and this is all I got. You can probably point to it being an undue financial burden. What I will say though is for private properties, the tenant actually bears the cost of fixing the property up to return it to its pre-modification standard, and they can be held responsible for the cost of the modification. But it's if you live in a federally subsidized property that I deal with the situation where the landlord goes, I don't want to pay it. But for a tenant, they can bear the cost. One thing to keep aware of is if you're working with any tenants and just want to help them get that modification, but they can't afford it otherwise, a lot of them, if they're getting SSDI or on Medicaid, they may be eligible for a waiver program. Are any of you familiar with the waiver program? Okay, so Medicaid runs it, and roughly anyone set up with the waiver program has about $10,000 in theory that they can use each year to pay for reasonable modifications. Does it actually work out to everyone's getting a $10,000 modification every year? No, because most people don't need that too. The money's not actually that fluid. But in theory, if someone hasn't gotten one in a while, or since they moved into your property, they probably could get in touch with a waiver program if they are disabled on Medicaid and going from there. Accommodations are your change in policies. Most often I deal with this with moving rental payment dates, helping someone get transferred to a ground floor unit, or letting them break their lease because they're now disabled. They live in a old Victorian home or in Victorian Village, and there's no elevator to get them down from the second story. This also comes up a lot with no pet policies and emotional support animals and service animals. This is usually when I get a groan from the landlord, so I'm surprised I'm not hearing a groan or like a violent eye rolling right now when I say ESAs are service animals, which is why this is my next slide, because usually I get pushed back both from landlords and I get sure from tenants. So I have this. Fair Housing Act requires providers to make a reasonable accommodation for individuals with disabilities to use assisted animals. Fun fact, outside in like the actual service animal definition, the two examples given, a dog and a miniature pony. The miniature pony actually has a really good reason for it. If the person's using a service animal to help stabilize them, it is a much more stable creature than a dog to help keep stable and let someone walk along it. So it was one of the two explicit examples, but more things can be a service animal. In theory, a capuchin monkey, not in theory, that was actually a case and I loved reading it. A capuchin monkey was designated a service animal and the failure to allow it was viewed as a violation of the Fair Housing Act. That one, the person was a quadriplegic individual and they allowed the monkey, they trained the monkey to go get everything for them. So the monkey would get the remote, the monkey would get food, the monkey would go get the mail and bring it back to them. And they tried to open the envelope. It was really fun. And also very effective. So it's why it's a good idea to keep your mind open when you're thinking of, is this valid? Tenant needs, but they do need to be trained. Obviously that monkey was trained. If someone had shown up with a chimp or something that was just, I got a chimp, it's gonna help me. No. And that animal can't be a threat. While I think it's on my next slide, breed bans are actually illegal when it comes to reasonable accommodations. So you can't say, sorry, I'm not allowing your Mastiff or Pit Bull on this property because I don't allow that brand, that breed of dog, and you have it, I don't care, it's a service animal. That's illegal unless there's a municipal level ban on that breed. Columbus doesn't have a Pit Bull ban, but I do know, I think Reynoldsburg may. I could be wrong about that. Candidly, most of my cases are in the city of Columbus, but sometimes those outlying cities throw me for a loop. If that municipality has a ban, you can still say no, but minus a municipality ban, you can't refuse a pet, a service animal because of their breed. Best idea is to think of a service animal not as a pet, but as a medical equipment piece. That same with support animals. It's basically like someone brought an oxygen tank, minus the whole ban on smoking cigarettes near oxygen tanks. But that's another issue I deal with often is have a lot of clients with oxygen tanks who are smoking cigarettes, and I have to explain to them, you can't do that inside. You gotta go outside and far away from the property because that could be an issue. But yeah, think of the pet as a service animal. Yep. Mhm.
What happens if someone gets bit by this animal and they chew up? How do you handle that? And another question to follow up on that. What happens when kids that bring in pets into the apartment where there are multiple students in there where a kid is allergic to a cat and one kid wants to bring in a cat and they're not sitting there arguing with them about, you know, who's right, who's wrong, whether it's allowed.
So the first question, you're not going to like my answer. My advice to you is go find a different insurance company. Because while the insurance cost of that dog biting the tenant or the neighbor may be a problem, the cost of the lawsuit from a fair housing disability claim can also climb steeply, and you would also end up paying my fees because there are attorney's fees in fair housing lawsuits. And despite me being a legal aid attorney, let me tell you, my hourly rate currently is about $4.50 if we're doing calculations of attorney's fees. So you don't want to pay attorney's fees. So it's probably going to be a lot. It gets messy. There has been some recent lawsuits filed around that issue, but it's a new enough issue that I don't actually have a good answer for you right now in the state of Ohio, what that would fall about. But to avoid the headache, I generally advise landlords just try to find a different insurance company. And I know that's easier said than done, but just try to save you guys some headaches. Now, for the disability versus disability issue, I've actually had a few Ohio State students where that was something I was dealing with. Um, it's hard what you at that point because you're trying to weigh two different disabilities against each other. Candidly, at that point, what I do is it's a reasonable accommodation. You're in an interactive process to do what is most reasonable. And what might be most reasonable at that point is, hey, I'll let you break your lease and move somewhere else without charging you a fee or without doing something or having an issue there. But if you need this service animal, you need to move somewhere else. I did have a client once say, well, can you force the other tenant to get kicked out so that way I can stay here? And I go, no, can't do that. Can't do a reasonable accommodation to make you break someone else's contract. But when it's two disabilities, the whole idea behind a reasonable accommodation and modification is this interactive process. So like if I come to you all with an accommodation request that you deem unreasonable and you can actually point to me why it's unreasonable, if I can then come to you with a different option or better practice would be to offer me a separate option to be like, hey, this still gets to the same point, but it doesn't have this impact on me. And then we go from there. Where I run into that actually most often is with hoarders. Hoarders are kind of the bane of my existence just because I feel bad for them and they also are so hard to actually help legally. But they can pose a direct threat in theory because you have roaches, you have fires, electrical issues from all the stuff they're stacking up. What I did once was I asked my client to get 4 months to clean the place up, or then they could, and the opposing side went, that's not reasonable. There's too much of a fear of there being danger from flames, et cetera. And we have roaches. And I go, fair enough. And so we went back and forth. And this is an example of the interactive process. We then came to a thing where she could get 4 months to clean it, but every week she had to provide the landlord proof that they had cleaners or someone coming in to work on it. Because then we would point like, yes, there is a threat right here, but we can minimize it by direct cleaning right now. And we were able to set up goals for each week to be like, we need to have this. So the first thing was we had to have every door and window clear pass because that was the biggest concern the landlord had. So that's an example, like you don't have to give that tenant the exact thing they request. If you have an actual reason why it's unreasonable, be it an undue financial burden or be it a direct threat issue, you can come back and be like, how about this instead? Now, I will say, because I've had landlords get in trouble with this before, don't have your first response be, I don't want to deal with someone with reasonable accommodation. You can break your lease. Because just if you completely blow past it and go, I just don't want to deal with this, and you don't give a reason for it, you just go, you can break your lease. That gets a little murky, and that could be viewed as retaliatory or not a proper action because you're basically saying at that point, you should just move somewhere else. I don't want to deal with your disability. Usually it's not that clear. I did have one landlord who put, again in writing, thank you for making an accommodation. We acknowledge the difficulties of having a disability. We think it's best you find somewhere better suited for your disability. We actually had 5 lawsuits over that one because they just kept filing a new eviction on the same notice. And we just kept getting it dismissed while also including it as a new charge because it was showing up on her credit as a eviction filing. So while breaking the lease or allowing a tenant to break a lease is an option you can give them, it shouldn't be your first go-to. You should first see, can you make the accommodation that they're requesting? And if you can't, lay out what the reasons are, and it needs to be either a direct threat or pose an undue financial burden, which can be when it comes to reasonable accommodations. I've only ever had one case where the accommodation itself posed an undue financial burden that I fully agreed with the other side. And that was when I got the client after she had made the accommodation request. Her request was, hey, I just became disabled. Can I not pay rent for the next 4 months until I get disability? And I said, nope, because unfortunately at that point, that's not a landlord-tenant relationship. That's a friend who's letting you stay when you're having a hard time. But generally, if it does pose an undue financial burden or is a threat to the community, you can just say no. Otherwise, work with them at what they've requested and lay it out. And backtracking a bit, fair housing law can be complicated. This is why when I make a firm statement, I then have to give at least 6 clauses on the side. If you're going to say it's an undue financial burden, be prepared to explain it and show it. Because my first question is going to be, oh yeah, show me. Show me right now the calculation you did. And like I said, you need to actually show it's going to financially undo, like it's such an undue burden, it will significantly impact you. It can't be, again, that $21 million portfolio company was really upset about the $8,000 they were going to lose in their profits that quarter. And I said, too bad. That's not the burden. They were making 2 million every quarter in profit. And I was like, no, 8,000 is not it. Like I said, evaluating request, if they're disabled and they make the request, it should be permitted. The request does not need to be in writing. I actually have a lot of fights with lawsuits and other housing providers about this. The request can be oral. Is it better to be in writing? Yes. And whenever I make one, I'm making it in writing. But if a tenant comes up to you and goes, I need accommodation, you have to work with them. You raised your hand? What's up, ma'am? Yeah.
What's the rule on that?
Also, the max I ever got was 6, but that's not a hard rule about you need to give 6. The rule is generally what I advise people on is each service animal, support animal, something has to have a particular purpose. And it can't get to a point where it's causing direct threat or endanger to the community because of how many people are there. I did have someone who tried to move in 12 dogs once. And I told them they were running a breeding home, not a emotional support location. Because all of a sudden she went from having 2 dogs to I need 12 now. And I said, nope. So we ended up parting ways. But generally the evaluation is each service animal / support animal doing something particularly specific to that pet? Because I did have one where there was one dog who was there to help them with detect seizures. There was a cat that was a support animal, and then they had another dog who had been trained to help them with walking and stuff in different places. But they were each one was different. Yeah, ESA is generally probably one unless you can show a connection to all of them. Yes, I had one client who I wanted to help her. She was a sweet old lady. She had 6 cats. She goes, they're my ESAs. And I go, okay, are you disabled? She goes, nope. And I go, so you can't do any. But if she had gone further, she would have been able to have one unless she could have shown that each one somehow did something. And with an ESA, that's almost impossible to show. Now, I did have one case where we were able to keep 3 ESAs, and that was because the client's emotional, like the disability stuff, she'd become so emotionally attached to those 3 cats, and those 3 cats weren't causing like a clear issue to the sanitary conditions of the property. To lose any one of them would have caused her to fall into a depression spell. But it's really, everything is fact specific. So like generally I'm going to say 1, but don't do that as a hard fast rule. If someone's coming, like if I had a client come to me and say I have 6 cats at my ESA, I'm using cats because usually when I get to a bigger number, it's cats. I don't usually have a tenant who's like, I need 5 dogs for an ESA. I'm probably gonna be really skeptical and tell them no, unless you can give me a doctor's note that shows you need it. But generally, there's no hard and fast rule. And I know that's not a great answer, but that's the only answer I can give you without leading you to go, God, I hate legal aid.
On second floor and person on the first floor says it's continuous. That's all I can hear, romping all night, but it's an ESA with, but it is large to be on the second floor. But they don't want to be downstairs because, they requested the second. It's becoming that where you don't know what you can and cannot say. You cannot charge deposit either on examples.
Correct. You cannot charge a pet fee deposit or charge them a pet fee because it is it's a medical equipment. It's just, it'd be the same as charging someone for that oxygen tank to have like a monthly fee to have an oxygen tank. I'd tell you to consult with an attorney if you have that matter come up because it is such a fact specific thing. As a general rule, being tenant side, I'm probably gonna be like, well, that really sucks to have tenant underneath them, but unless they have a disability showing that they just really it's setting them off in some way, it sucks. But sometimes it's like, yeah, you don't have a right to not be annoyed. Candidly, most of my clients are annoyed by a neighboring tenant for something. They don't get to then break their lease because of it or hold the landlord responsible for it. So I'd say consult with an attorney. And I know it's not a great answer, but it's just each one's so fact specific. Mm-hmm. Mm-hmm.
A lot of times I'll give my comfort, but it's really pet. and I'm dealing with college students who don't take care of these animals, no matter if
Yeah.
they're service animal or a comfort. And so that's the second part of the question is, what if they don't clean up the feces and all that kind of stuff? You know, what are our rights?
Yeah.
As a landlord, take care of other tenants, you know?
Yeah.
That poses a health risk to them. So two-part question.
So answer your second question would be that whole undue like risk to the health and safety, direct threat to health and safety that I talked about, how that's the reason you can deny. If the dog ends up being vicious or like is attacking people, that dog just either needs to go through classes that the tenant has to be responsible for paying, or just need to get a different service animal or emotional support animal. Same way that if they're not picking up after their feces, they can be evicted for not picking up after their feces. I don't want to be seeing you all in eviction court because I'd be on that side and that'd be a bummer because like you guys all kind of like me right now. And if you won't like me when we're in court because no one does. But you can still evict someone because even though they have a service animal or you say that dog is going to the bathroom in the apartment and it's causing a smell issue throughout the community and things like that. Yeah. That's something you can do. Now there might be a little bit more wiggle room if like, for instance, the client's in a wheelchair and so can't get out to get around the yard. But that at that point, the question would be like, okay, well, we need to figure out someone to come and take care of the feces. But yeah, now as far as the proof they need to show, a doctor's letter is usually sufficient. You can ask for a little bit more evidence from a doctor's letter than a doctor's letter, but you need to be really careful because if you go, tell me your specific disability, and you start digging in really hard, that can be open you up to some liability. Now, I will say, just for all your sakes, for clients' sakes, for my grandmother's sake, because my grandmother called me about this once, online LAC at sandiego.com is not a source you have to trust. Like, also, there's no such thing as a emotional support or service animal license. I have a lot of tenants, and as I said, my grandmother, who will spend $60 that they don't have on this online service fee because, well, I heard I had to get a license. So I looked up ESA license and I got it. It's a doctor's letter. You want a doctor's letter. So you can ask for a doctor's letter. If the doctor gives you a letter saying they need it, you have to listen to them. But they can be, if the dog's just like causing damage to the property excessively or biting people or isn't cleaning up, you can take actions from there. But be prepared to show that evidence up front, just because you're gonna have to deal with it.
Back when you said about the I've had tenants that I realized they have an animal, but they did not disclose. And I said, we have to do a pet addendum. This is in violation of the lease. And 2 days later, it was even dated that 2 days later. Now it's an ESA animal. Their doctor said they have to have it.
Honor that, as annoying as that is for you. Because candidly, I get clients who they're disabled. They have some severe mental disabilities. They're on the autism spectrum. They don't understand what they had to do at that point. So then they get a call, they call me because they go, hey, my landlord says I can't have this pet and that they're going to evict me or I need to get a pet addendum, but I use it because of this. And they start talking to me about it. And I go, oh, this is your support animal. You need, like, this is clearly like your doctor told you need to get this. You got it. You just didn't get the official letter from your doctor. Go get that letter. Now, if you had a fee that you were charging them and then they got you a letter, you can charge them for everything before they got you that letter. It's just up to that point. And so for this situation you described to me, you just found out about the dog. Then they gave you 2 days later, they gave you the letter. At that point, you just got to accept it. But if you had like a pet fee, you were charging that tenant that pet fee every month. And then on the 6 months, they gave you an ESA letter. You can still charge them for the previous 6 months before they got you that documentation. You just can't going forward.
And moving forward, we're not going to collect any money.
Probably technically, yes, but be very careful. Consult with an attorney because the timeline there could be so specific. Like if you charge the fee and then they get you the letter, sure, but like if they got you the letter and by the time your program processes the fee, it shows up a day after they gave you the letter, then it starts to me, without knowing all that information on your side, looking like retaliation. And then I'm like, okay, let's go. And then you can have a whole fight there. So just consult with an attorney. The attorneys are the ones who wrote the law. We wrote the law so you had to talk with us because we wanted to keep a job, let's be honest. If the laws were easy and straightforward, I wouldn't be necessary. You could go do it yourself. But a bunch of attorneys wrote the law with an interest of keeping their jobs. So unfortunately, everything say it depends. I had my wedding 2 months ago. I almost, with both attorneys, we joked about answering it depends when instead of I do, just because attorneys can never give a straightforward answer. Determining reasonableness, like I said, if it causes an undue financial burden, if it's a fundamental alteration to the nature of the housing provider's operation, again, that example of, can I just not pay rent for the next 4 months falls under that clause, or if it poses a specific demonstrable direct threat. I talked about direct threat a lot. It's because it comes up a lot because there's a few attorneys in the city that like to bring up everything as a direct threat. You need to be able to point as a direct threat, and also it can only be a direct threat that's significant to deny a reasonable accommodation if you show that they would still be a direct threat after that accommodation is granted. And it needs to be something you can actually prove. So I did have one landlord who tried to just refuse to rent to my tenant who had schizophrenia because, quote, well, he could start a fire or he might do something to the property. He had posed no direct threat. He hadn't done anything like that before. That wasn't a reasonable denial. Alternatively, I had a client who once did start a fire because of some hallucinations they were having. That was a reasonable thing to be like, no, we don't want to grant the accommodation because they could do it again. Now, when I came to them on another client who had done that, but I was able to point to them and be like, look, they've changed their medication. They're seeing a new doctor. They're doing all these changes. They did work with us because that was the correct answer. And in that circumstance, you can still hold that person responsible for the damages that occurred at that point. I'm not saying, hey, my client burned 2 apartments, but now she's on new meds. Swallow the cost. Sorry. But just like generally my recommendation would be work with them still on that, like set up a payment plan, do something like that. But yeah. General landlord tenant, real quick. You guys know this. The lease is what matters. What your lease says is what controls, unless that lease says do something illegal. I had one landlord who, not to bring up my grandmother again, was renting to my grandmother and tried to say, you can't file escrow. That was in the lease. The escrow was not allowed. And I said, Grandma, that's not enforceable. And also, that I, as an attorney on tenant side, would love to have that in the lease when we were doing an escrow complaint. You all have to keep the place in fit and livable condition. You need to keep electric, plumbing, heating, all that working. If you provide an appliance, you need to keep that appliance working. As you all probably know, but I'll say it anyways, if a tenant brings an appliance, you are not responsible for keeping that appliance working. I had a client who didn't pay rent for 2 years because, quote, landlord won't fix the washer and dryer at the property. We got about 2 months into talking with the opposing side when finally it came up from landlord and confirmed my client. Washer and dryers were my client's washer and dryers. They had just provided the hookup. So you're not responsible for the appliances that the tenants bring in, but you are responsible for appliances that you provide. Now, if the tenant's misusing that appliance, you're also not responsible. So I had a client who kept using the oven because the place wasn't hot enough for her. So she just kept turning on the oven and leaving it open to try to heat up the house. Not responsible for that oven breaking. Now, I had another case where that happened, but the heat in the entire unit had been out for 4 months and we were in a polar vortex. That was a different conversation. And we did include the oven as damages because we said you went 4 months without giving this woman heat and we had -6-degree temperatures last night. So yes, we're not gonna just say, oops, my client used the oven at that point. I guess she has to pay the bill. Tenants have to dispose of trash. They have to comply with housing, health, and safety codes. Y'all need to provide a garbage can to the land. Let's make sure they have some way of getting rid of trash. The city provides garbage cans, so you're generally okay. But in communities where that's not the case, under Ohio law, you need to provide some method for tenants to get rid of trash. You need to comply with building and health safety codes, and you need to give a reasonable notice before entering the house. This then is usually a big fight, and I get real bitter about it, but I also understand why y'all get bitter about it. Generally, it's 24-hour notice. You gotta give a 24-hour notice before you show up. And preferably that 24-hour notice won't be, I'm gonna show up sometime tomorrow. Stay there so I can be there. Preferably you give them a specific time. An exception to that is if the client calls and says, hey, there's feces coming down from the ceiling, they need to let you just come in. I say this from horror of experience because I had a client who just goes, nope, they didn't give me 24-hour notice. I go, ma'am, there's literally, excuse my French, shit coming from your ceiling. I think you just need to let the landlord come in and look it over. So you don't need to give 24-hour notice if there is an ongoing emergency. I'm going to stress emergency. happening at that property with the maintenance or condition of the property. The reason I'm stressing emergency is 'cause candidly, a lot of sex-based discrimination claims come out of landlords who really think emergency is, I haven't seen this tenant in a little bit and I want to keep seeing her. I'm just going to keep coming in. So give the notice, put it in writing. Writing can be text, writing can be an email. I've even seen a DM on Instagram count as writing. You just need to give some written kind of 24-hour notice to the tenant unless there's an emergency. Landlords need to provide running water that is reasonably hot unless the name is purely in the tenant's name. So if you have the tenant pay you water and then you pay the city, even if that tenant falls behind 6 months on water, you're responsible for keep giving them water. The only time the tenant's responsible for that is if the water is in the tenant's name. At that point, you don't have a duty to keep making sure they have water. I did have a landlord who got really angry about this. I understand it can be frustrating to some of you all, but also it's water and you don't want to like cause a 4-year-old not to have water because mom and dad didn't pay the bill. If it's in their name, it's their responsibility. But if you charge them for water and they pay you, you just got to keep giving them water. You can hold them liable in court. You can sue them for the financial duty of cost, but you have to just keep giving them water. Duty to the tenants. Tenants are responsible for the damage they cause and that of their guests. Real question about who is a guest, though. I had 2 Kia Boy cases. One was a guest, one was not. Tenants' kids were friends with some Kia Boys. They came over and hung out with them, and then within 30 minutes of them being at the property, they had broken into someone else's Kia and then drove it into the property manager's office. That was a guest. Different set of clients with a different set of facts. Kid was also friend with some Kia Boys. They had left though 4 hours before and came back. Client and client's kids were asleep. They came back, held someone up, and stole the car. That was not the guest at that point because they had been gone for 4 hours. The tenant was asleep. Kid didn't even know they were there. But the one where it happened all within 30 minutes and no one said goodbye and everyone was still hanging out. The tenant did get evicted for having her son's friends drive the car into the property manager's office. Shocking, I know, but it happened. You can't disturb other neighbors or require guests to do the same. This is actually a different case where neighbors got held up by one of my clients' guests hours after the fact. They would have been held responsible if those were still their guests. You all know evictions. They're called forcible entry and detainers. Actually, I don't know how often you guys deal with evictions because candidly, I don't see many OSU students or adjacent properties at eviction court, which I'm happy with. Believe me, I don't like seeing people there all the time on either side because it's a headache for you all to be there and it's a headache for me to deal with you. But there's 2 types of eviction, first cause and second cause. First cause is what we all think about. That is who gets to live here. What are we going to do? Second cause is whether or not you actually have a right to collect on that back owed money. So any financial damages you're trying to allege, if you're trying to get the court to order it, you need to file a second cause. Now, before you go ahead and go, haha, I'm going to file a second cause. That way I can get my money. Again, one of my favorite words, consult an attorney, because there are some extra duties and obligations that can come about if you file a second cause. And that could actually lead to you having to pay money because you did a second cause but didn't do some other things correctly. Probably familiar with the timeline. If you give a 3-day, they have 3 days until they have to be out of the property before you can file an eviction. If you have a federally backed mortgage at your property or you're accepting anyone with a housing choice voucher, you need to give a 30-day notice for non-payment of rents under the CARES Act. It's candidly one of my favorite laws, but for all the reasons that would cause you all headaches. Because if like you file on the 29th day, it can be the second hearing. I finally got in touch with this client. We're 45 days from when you actually gave the notice, but you filed on the 29th day. I can get the whole case thrown out that day. Just be like, yep, throw it out. And then you have to give a new 30-day notice, go down that whole line and go from there. Non-renewals are an exception to like the whole CARES Act thing. You need to give a 30-day notice. Well, let me backtrack. CARES Act's only for non-payment of rent. Non-renewals, you need to get 30-day notice, but that 30-day notice is weird because if you give that notice today, it's not November 8th that you get to kick the tenant out. You have to wait till the end of November. So it's effective the leasing term 30 days out from when you gave that notice. So if you gave it on October 1st, yeah, they need to be out October 31st. But if you give it on October 2nd, and I've won multiple cases on this issue too, I can be like, actually, they don't have to be out to November 30th. They filed prematurely. So unless you're filing on the 1st, any non-renewal notice is actually going to be effective in court the following month. Can I just raise your hands real quick? Does anyone here run like a project-based housing property? I'm guessing not. Okay, that's like a 15-minute diatribe, the subsidized 10-day meeting conversation. I'm not going to go through that. If you ever run project-based housing, read the HUD guidebook. There's a lot of stuff that I can make real headaches for you all in. If you file an eviction, you go through 2 weeks usually is in Franklin County, how quickly an eviction gets filed. We have the, I believe, 3rd busiest eviction court in the country. We're on pace to pass 25,000 evictions this year. It's how I have a caseload of, I've been at legal aid for 5 years. I've had 2,500 clients. But it takes 2 weeks to get there for that first hearing. And in Franklin County, generally, the idea is that every party gets at least 1 continuance. Is it written into statute anywhere? Technically, no, but that is what the local rule has been for at least the last 10 years. Be careful of the magic language. The magic language is the 5321 language. Look it up. You can just look up 3-day language. If it's off by a letter, I win. Again, I don't mean to laugh at the pain of landlords. It's just I deal with a lot of bad ones, and sometimes they make funny mistakes and they yell at me after court and it makes me chuckle. But there's a notice that in the notice it has language that says an eviction action may be taken against you. The landlord had put in a notice a eviction action may be taken against you. I got the whole case thrown out because they didn't say and, they said a. It needs to be to the letter correct. If it's not, the whole case can be thrown out. And it also needs to be conspicuous. That means when you look at a 3-day notice, that language needs to be the first thing that your eyes get drawn to. So if you have a notice that has like a bunch of underlines, a bunch of bolds and italicizes, and someone put emojis in the notice once, you better make sure that the only thing that you see at first, and literally the test is I hold it out here and I ask the magistrate, Your Honor, what are your eyes drawn to? It needs to be that 3-day language. Exception to the 3-day is for failure to maintain properties under 532111. You need to give a 30-day right to cure if they're doing like conditions issues that they've caused. So if it's they keep piling trash out on the front porch, things like that, you need to give them a 30-day notice that they have a right to cure. And if they don't cure it, then you get to evict them. These are possible evictions. Again, consult an attorney to make sure that you don't have a defense to this eviction, to your eviction in your complaint. But if you give a 3-day notice after filing a 3-day notice, after already filing an eviction, that's waiver. So you can't, like if you file a 3-day notice, don't just, well, I want to tell you, just keep giving them a 3-day notice every 3 days because that makes my life easier. But for you all, don't do that. Like just rely on your one notice and go from there unless an attorney don't file on that first notice. If it doesn't have that magic language, if you don't actually go 3 days, I love counting on my fingers to a magistrate and go 1, 2, it was only 2 days, Your Honor, and then case gets dismissed. If the tenant in City of Columbus, if the tenant offers you all of the back rent and you refuse to accept it, that is a defense now in the City of Columbus. That was not always the case. So this changed about a year and a half ago. It's called the Pay to Stay Act in the City of Columbus. And you don't necessarily have to accept that money, but your failure to accept that money gives me a defense in the eviction hearing. So if you owe you owe back rent and fees, well, sorry, if your tenant owes back rent and fees and they come to you with all of that before the judge goes, you're evicted, in the City of Columbus, you're supposed to take it, or that can be a defense to the eviction. Now, I'm sure some of you are thinking, what about third-party rental assistance and how does that work? The question is tendering rent. So it's if they are trying to give you that money right now, in theory, with rental assistance, if they had like, we cut the check and here it is, please take it, that could give rise to defense. But most rental assistance programs, you all need to participate to get to that point. So I don't expect that to come as a shock to you if you get to that point. Alternatively, if you always accept rent late, so I had a client who she always paid rent on the 8th. Every month it was on the 8th. Without giving a written notice, the landlord one day just goes, got it. One day the landlord just goes, I need it on the 1st now, but doesn't give written notice, anything like that, and then files an eviction on the 6th, 2 days before she usually paid rent. I was able to pull the bank account and show that she paid rent for the last 3 years on the 8th, and we got the case dismissed because they created a pattern and practice outside of the lease. Okay, Columbus specific defenses. I said right to pay to stay. Self-help eviction, don't do it. Just don't do it. I'm sure you two, the officers in the middle, get calls for landlords throughout the city trying to do a self-help eviction. Don't do it because it's technically illegal and also because it can open up a lot of financial damages, double damages. So I get to just double whatever can point to as damages in my lawsuit against you, and as attorney's fees. And as I said before, everyone hates paying attorney's fees. Don't do it. It's expensive. I'm one of the cheap attorneys in theory, and like I said, $400 every hour. So this presentation would cost you $400 if we were charging. Let's go. You all familiar with escrow? A tenant needs to give you something in writing to tell you need to fix the property. It needs to be in writing. They need to give you all a reasonable amount of time to fix it. Much like the 24-hour notice is a moving scale, reasonable amount of time is a moving scale. If it's the heat's out in the middle of winter, you don't get 30 days to fix that. You need to be quicker. If you all don't make that repairs within the reasonable amount of time, the tenant can then start doing one of two things. They can either start filing escrow, which means rent's paid to the court every day, every month on the time it's owed, or they can just break their lease and you're not able to sue them for breaking the lease fees, things like that. A lot of people try, but you're not allowed to. If eventually the landlord fixes everything, what happens is the court goes, okay, it took 6 months, you had no bathroom and the second floor bathroom was gone. Okay, we're going to deduct what the cost of not having both bathrooms that you paid for would be over 6 months and give you that money. The rest of the money left over we're giving to the landlord. One time the landlord got nothing in a case I had, but that was because the landlord took a year and a half and my client had 3 rooms with a collapsed ceiling. But my client was disabled and poor and didn't have anywhere else they could go. So they were just living in that property. So the court correctly, in my opinion, said you didn't deserve any money for any of that time period and just paid rent to my client. Retaliation. Don't retaliate against a tenant for doing any of their rights. Like for fair housing, for instance, if you go, hey, I want this reasonable accommodation request, if the tenant says that and then the landlord goes, nah, and then like tries to file an eviction or something, or grants it and files an eviction, you've created a fair housing lawsuit that didn't exist in the first place. If they contact code, I know you guys hate it. I kind of hate it too because half the time code just either does nothing or nitpicks on a few things where I'm like, that's not really the issue I wanted you to attach. And why do we care if one light bulb's missing in the 3rd bedroom? Don't evict them. Just generally don't do something immediately after they do something that seems legal, even if it's annoying. Because it's really a timeline question. If you guys wait like 4 or 5 months after code, I'm not saying then evict them because I'll still have a fight and that's annoying for everybody, but you're likely not going to get found in violating the retaliation statute. Source of income discrimination. In the city of Columbus, you cannot deny a tenant because they have a voucher or some other third party paying their rent. Now, you have to treat them like other tenants, so you don't have to say, you don't have to take them. I had a lot of clients who, when this first passed, thought, well, I have a voucher, they have to take me. And I said, no, they can still deny you for other reasons. What I will say is, I don't know how common it is here, but the 3 times a month's rent and income rule, when it comes to using a voucher, the way you calculate that is 3 times the tenant's portion. So if the tenant's portion is only $33 a month, as long as they make $66 a month, they pass that 3 times the monthly rent income test. This is actually a criminal statute, and I do know that the city attorney's office is investigating a few different landlords to press criminal charges against them for violating it. So you don't deal with me then you're dealing with the city attorney's office, and that's a different headache for all of you. Third party tender, if the tenant's not behind on rent, you do under city statute have to accept payments from someone else. Where I run into this the most is child support situations where instead of paying child support that month, the client can ask their ex if they could just pay rent for them that month. And the landlord goes, no, I don't want to do that. I'm not going to do it. And you go from there. Churches also, I've run into this not infrequently with churches where churches will try to help their parishioner by paying rent. And the landlord goes, no, you have to accept it if they're not behind on rent. If they're behind on rent, that's a different conversation. And you don't have to participate in a third party rental assistance program if the tenant's behind on rent. Candidly, I'd say probably do it. That's just me being selfish because if you can get the money, great. That fixes your headache in the first place. But I understand there's a lot of hooks that come in with rental assistance that make it to where landlords don't always want to work with them. Rent receipt, just give every tenant a receipt. If you have an automated generating portal that just generates a receipt every time a payment's made, that counts. But you do need to give a receipt to your tenants anytime rent is paid. One last one I didn't include in here because it don't have a good excuse for it. I'm going to call it wedding brain because I'm still recovering from planning that wedding. If you have a tenant who can't afford security deposit and they come up to you and you rent in the city of Columbus, you need to either let them break it up into a 3-month payment plan or a 6-month payment plan under city statute. So just keep that in mind because that could open you up again to criminal actions from the city attorney's office. I believe it's a misdemeanor. So it's not like the worst thing in the world, but you don't want a misdemeanor on your record if you don't have one already, because that just creates a lot of headaches for everyone. Any questions for me? If they live in the city of Columbus, yes.
So, according to that particular statute.
Oh, you got a statute pulled out. Let's go.
G.
Mhm.
And says that, nothing in this section shall construe so as to mandate that an operator require a tenant to pay a security deposit. And nothing in this section shall be construed to prohibit the use of alternative lawful means of providing assurances as to the performance of the rental agreement. Could you give us examples of what those alternative measures and assurances might be in lieu of the security deposit?
Yeah, so there's a company called Rhino. I don't know if any of you are familiar with that. They're a rental insurance company. They will sometimes have, I have some clients that do this. And candidly, if my client can afford to pay security deposit, I think it's better just to do that. But where they will do security deposit alternatives, and you're effectively paying an extra fee on your rent each month to pay for a security deposit. It operates as some kind of like insurance policy, is my understanding, because in theory, if you're only there for a year, it's usually not the same as 1 month's rent. But that's one of the legal alternatives you could do. Because the first part was saying you don't have to have a security deposit. And that's correct. If you don't want to, you don't have to charge a security deposit. The second part is saying if you participate in Rhino, for instance, I'm just using them as an example, not endorsing, because they're kind of a headache for the landlords, is my understanding. You can use with them. And then that's setting up a monthly payment, not a 3-month or a 6-month, but it's an alternative to security deposit. Mm-hmm.
Campus.
Mm-hmm.
This person comes around and you have a non-performing tenant on the lease, it's really difficult to get that unit built.
Mhm.
We're often signing leases 10 months in advance
Mhm.
of the next school year, and the security deposit often presumes that they're gonna perform their end of the lease. Are there any other protections that we could offer as an alternative to that? Because that feels like an unnecessary exposure. For instance, an apartment reservation fee at the time of lease signing. I mean,
I think that would be allowed. Like, I don't think there's nothing off the top of my head that screams that's illegal to do. Now again, it's partly going to be the contract, and it's going to be like if you put someone in, and you have them sign a lease because I know you're worried about non-performance of the contract, and they just break up security deposit over 6 months, but then they don't come, you can hold them responsible for that entire security deposit still at the end of the day. No, yeah, and I had a conversation with a tenant. I think this is a tenant and landlord thing. Everyone wants to avoid court, and in certain circumstances, there isn't an alternative. You're just gonna have to go to court and go after them in small claims or sue them in some other form to get the money back for a failure to perform. When it comes to if they signed a lease and then don't show up to the property, you can charge them the cost of that rent and then come after them to collect it until you re-let the apartment. Now, what you need to do is constantly be trying, because I had one landlord who tenant broke the lease without fulfilling it. They moved out in like the 6 months, the 6th month of the lease. And that landlord just sat in their hands for the next 6 months and then tried to sue them for those 6 months rent when the tenant wasn't there. I was able to show they hadn't mitigated their damages. You need to show that you are trying to re-let the property. And at that point, you can charge that tenant for all the months that they didn't pay rent and you weren't able to re-let the property.
right now.
Mm-hmm. Mm-hmm.
With no money at all.
Mm-hmm.
August rolls around, the end of July. Oh, sorry, I don't need the apartment anymore. It's extremely difficult to rent.
Yeah. At that point, you have a breach of contract, and that's like, unfortunately, like, you can do a security deposit, you can do a fee. If the tenant agrees to sign it, that's fine. There's nothing in that statute that's saying, yeah.
In lieu of a security deposit, could you require them to have an apartment reservation fee, for instance, that would amount to perhaps half of what you would normally charge for a security deposit?
Probably, but heavily, like, it depends. Like, I think what you're saying to me right now, without any research on my part, that seems like something that would be legal. But again, if I was to, legal, that seems legal to me. But if I looked into it and then found something different, the answer could be different. Yeah. Oh, believe me, the amount yeah. No, and so that's why I'm saying probably, but also as far as a lot of lawyers not knowing, lawyers are just people. I meet so many dumb lawyers. I meet so many lawyers who think that they know what they're doing, and they go, I've done this for 25 years. And I go, you've never been in landlord tenant court. You don't know what any of this is. Yeah, that would be good. Like, that'd be legal. Like, you can be creative. Like, unless it's something expressly like deemed illegal in the city or a state statute or federal, you can be creative in contracting. Like, as long as it's not something that is illegal in the contract, you can work around it to try to come up with an alternative. Now, I'm not saying down the road, if that became the norm and it became an issue that the city wouldn't pass something to say you have to change it, but like right now, it's not the statute. So you can be creative.
When we're signing a lease, we simply reference could we simply reference this particular thing in the Columbus City Code, or do we actually need to spell it?
You can just reference. You can, yeah. I see it all the time in statutes, federal and state level. Ma'am, in the, yes.
How's it, but then I was finding that people were coming here.
Yeah.
They were, around Christmas time. They were like, by that time, they said, friends they met and they moved because they want to do that. It's not happening for you, I think.
Yeah.
So for me to specify my reason.
Yeah.
So, if people, and I know people need the OCD, so can I say, okay, you have to pay half the deposit now, sure, and then half the apply, or is it, okay, why is it then?
If the city, under the city statute, you can ask for the whole security deposit up front, but if the tenant goes, hey, I can't afford this, it's called renter's choice. So it's not that you have to give the tenant that option right off the bat, but if the tenant goes, I can't pay that security deposit, can I break it up over 3 months or 6 months? You have to then work with them. But I'm not saying you have to only charge 1/3 of your security deposit up front. You can charge the whole thing up front. If they can, it's just if the tenant asks, I want to adjust this policy to one of these 2 plans that have been labeled by the city as appropriate, that's when you have to change. So yeah, you can ask, I need you to pay half the security deposit up front. It's just that the tenant then, and candidly, if they're an international student or coming over from overseas, they're probably not going to be aware of the city statute. I'm not saying take advantage of that. I'm saying, like, I don't expect that that's going to come up for you at that point. If I'm wrong, let me know, because I'm actually curious. Mhm.
Deposit, and the other must be due.
Yeah, unless they ask for a different policy, that's fine. Like, if they ask for the 3 months, you have to work with them on that 3 months in the city of Columbus. But my answer for all of this is, if someone's just moving out halfway through the lease, sue them. Like, if you want that money, you need to go to court and get off them. That's my only advice for you on that. I think I'm done now, but I will stay a little bit afterwards if people want to come up and ask questions. I can only give general information or, yeah, legal information, because we don't represent landlords, and landlord matters, though. If you're a senior and you have other issues, we don't have an income or asset limit for seniors. So other legal issues like wills, things like that, we can help with still, but we don't represent landlords and landlord tenant issues just due to conflicts.
Amazing. Thank you, Nathan. Sorry to bring out the cane on you, but I was hoping that you would be willing to stick around if there are some additional questions. We do say this ends at 2:30, so I want to make sure I'm more mindful of everyone's schedules here. But really briefly, just a quick reminder about the December roundtable. This is going to be an opportunity where you can have, you can earn up to 2 in person of your credits at December if you would like to do that. It's going to be a half day. We have had requests from property owners about choosing your own path and what you want to learn. So this will be a great opportunity. So just a reminder, this will be on December 10th, 8 to noon, and it's going to be a great little morning here. So I wanted to give that a heads up. And then also our off-campus living expo. So just a brief reminder to those who have registered. You should have received an email from me. This is my email, stazen.5@osc.edu. That should have given you a lot of the information, if not all the information for the expo. If there's something you still need, you haven't received that, you think you should receive something different, please, please, please reach out to me. I'm happy to walk through that. And I wanted to remind everybody about the Buckeyes Living Off Campus newsletter advertising opportunities. We just had our first one run, and just as a reminder, the block newsletter does go out to 68,000 students, and it has a 26% open rate, which equates to about 13,000 students, which is really great. We ran the first ad with one of our property owners just recently, about 2 weeks ago or a week ago, and that had already roughly 12,000 students who had viewed that edition. So I just want to remind everyone about that. It is new. Please fill out the survey. Thank you for being here today. We're really excited to see so many of you at the expo on Tuesday. And if you want any collateral for the expo to share in your office, your property, wherever you want to do that at, feel free to pick some up in the back. But thank you all. Please hit up Nathan if you have any questions. I'm happy to help with the expo and anything else. Thank you. Have a good day.
Sorry for running a little.